Hello, my name is Caitlin Gregory, and I will be presenting the case Hackman versus United States versus Teddy Kiriakouridis. This is my student brief, case number 630 F period 3D 1078, and it's for a federal law appeal. This is also for the class ATE 3515. So for a few definitions for this presentation, the first one includes 18 U.S.C. 371, conspiracy to defraud the United States. If two or more persons conspire either to commit any offense against the United States or to defraud the United States or any agency thereof in any manner or for any purpose, and one or more of such persons do any act to effect the object of the conspiracy, each shall be fined under this title or imprisoned not more than 5 years or both. The second definition, 7 U.S. Code 2156, Animal Fighting Venture Prohibition. Any event in or affecting interstate or foreign commerce that involves a fight conducted or to be conducted between at least two animals for purposes of sports, wagering, or entertainment, except that the term animal fighting venture shall not be deemed to include any activity which the primary purpose of which involves the use of one or more animals in hunting another animal. The third definition, departure, means to provide authorized adjustments to a sentencing range within the guideline system. As Congress acknowledged in the Sentencing Reform Act and the Guidelines Manual itself explicitly states, it is difficult to prescribe a single set of guidelines that encompass the broad range of human conduct potentially relevant to a sentencing decision. Departures therefore perform an integral function in the sentencing guideline system. Departures help provide courts with a way to impose an appropriate sentence in exceptional circumstances. The fourth definition is upward departure. It may be warranted if reliable information indicates the defendant's criminal history category substantially underrepresents the seriousness of the defendant's criminal history or the likelihood that the defendant will commit other crimes. The court may use the following information as the basis for an upward departure regarding the defendant's criminal history. A. Prior sentences not used in computing the criminal history category. B. Prior sentences of substantially more than 1 year imposed as a result of independent crimes committed on different occasions. C. Prior similar misconduct established by a civil adjunction or by a failure to comply with an administrative order. D. Whether the defendant was pending trial or sentencing on another charge at the time of the instant offense. And E. Prior similar adult criminal conduct not resulting in criminal conviction. However, a prior arrest record itself shall not be considered for purposes of an upward departure under this policy statement. The fifth definition is de novo. An appellate court hearing a case referring to the lower court's record to determine the facts, but will rule on the evidence and matters of law without deferring to that court's findings. And the last definition is double count. Occurs when one part of the guidelines is applied to increase a defendant's punishment on account of a kind of harm that has already been fully accounted for by application of another part of the guidelines. So a little general background, which brought this case, is that in January 2008, an investigation was prompted by the Missouri Humane Society, U.S. Department of Culture, undercover Missouri Highway Patrol investigators, FBI, and other agencies had uncovered one of the largest dogfighting rings in U.S. history. They uncovered a multi-state dogfighting ring in Missouri, Illinois, Iowa, Nebraska, Texas, and Oklahoma. Altogether, 26 men from varying states were arrested and over 350 dogs were seized. Little background on dogfighting. Dogfighting is when dogs are forced to fight one another for the entertainment and or profit of the spectators. Dogfighting is considered legal and a felony offense in all 50 states. Many reasons for dogfighting for people who enjoy this is excessive amounts of money from the fight itself, money from stud fees, puppies being sold from good bloodlines for money, using animals as an extension of themselves to fight their battles, demonstration of power and strength, and or sadistic enjoyment. In the United States, the American Pit Bull Terrier is the breed of choice for dogfighting rings. Other breeds are used for street fights or used as bait dogs. So a little background on the appellates prior to basically trying to overturn their conviction. Between January 2008 to January 2009, Hackman and Kiriakouridis were involved in animal fighting ventures and dogfighting competitions. Hackman and Kiriakouridis established and ran kennels to purchase, breed, train, and condition Pit Bull Terriers for animal fighting ventures. Hackman operated the Shake, Rattle, and Roll kennel. The dogs were tested and selected for their fighting abilities and aggressiveness. This was done by using the dogs in roles, which were also known as test matches. And the dogs that came out on top were considered superior and were bred, while the inferior dogs were killed or sold. Test matches were also used to prepare the dogs for contract fights involving wagered money and actual referees enforcing dogfighting rules. Hackman was known as a reputable and respected fighting dog producer and utilized weight training, steroids, and different medicines to treat injuries, which created rigorously sought-after fighting dogs. He sold some fighting dogs for up to $2,500. Kirakiritis hosted a contract fight, and after an hour, one of the dogs was no longer able to fight. The owner of the dog decided to have her killed. Kirakiritis supplied the owner with a wire and clips to attach to the dog so it could be electrocuted. Kirakiritis was about to plug the wire in, but the owner decided he should do it himself. The owner plugged in the wire and the dog went into a seizure mode, but it did not expire. A third person came over, plugged the wire into a different outlet, and the dog finally passed away. Both defendants admitting to abandoning, destroying, and disposing of pit bull terriers that lost during fighting competitions. They would also do this if the dog was not aggressive enough, became injured, was wounded, or became disabled as a result of the animal fighting ventures. An investigation was launched, and 13 pit bull terriers received from Hackman's residence, and 24 were seized from Kirakiritis'. Various items associated with dogfighting were seized as well. Among the 5 conspirators associated with Hackman, 200 pit bull terriers altogether were seized. So the background on the previous court case before they were trying to get it appealed was Hackman was indicted on 4 counts. He received a stipulation and plea deal, which 2 of the 4 counts were dismissed as long as he pled guilty to 1 count of conspiring to engage in animal fighting ventures in violation of 18 U.S.C. 371, and 1 count of engaging in animal fighting ventures in violation of 7 U.S.C. 2156. Kirakiritis was indicted on 2 counts. He also received a stipulation and a plea deal, which 1 of the 2 counts were dismissed as long as he pled guilty to 1 count of conspiring to engage in animal fighting ventures in violation of 18 U.S.C. 371. The District Court of Missouri applied an upward departure provision contained in the U.S.S.G. 2E3(1) to each defendant for their crimes. In Foley, Missouri, Hackman was convicted of engaging in an animal fighting venture and conspiracy to engage in animal fighting venture. In Leesburg, Missouri, Kirakiritis was convicted of conspiracy to engage in an animal fighting venture. Hackman was sentenced to 1 year and 1 day in federal prison, and Kirakiritis was sentenced to 18 months in federal prison. So how upward departure works is there's three different values basically, and if the client meets 1, all 3, or 2 of these criteria, then the Missouri court was able to apply the upward departure provision to them. So upward departure includes prior sentences not used in computing the criminal history category, foreign or tribunal cases, prior sentences of substantially more than 1 year imposed as a result of independent crimes committed on different occasions, or prior similar misconduct established by a civil injunction or by failure to comply with administrative order. So for the actual appeals case was U.S. v. Hackman v. Kirakiritis. This case was heard on January 10, 2011 in the United States Court of Appeals in the 8th Circuit by Circuit Judges Hanson, Woolman, and Loken. For the appellates, both parties appealed to the 8th Circuit United States Court of Appeals because both appellates argue that their conduct that was associated with their previous sentencing is not cruel enough for the upward departure provision to be applied. For the appellee, defending on the behalf of the United States was Assistant U.S. Attorney Matthew T. Drake. So the issue with Hackman was that Hackman appealed his criminal conviction because he believed the district court was wrong to apply the upward departure for extraordinary cruelty because his legally relevant conduct does not amount to extraordinary cruelty as defined by the United States sentencing guidelines. He opposed that the district court considered his conduct improper, which was not legally relevant to his sentencing under the United States sentencing guidelines. He challenged that the court exaggerated its interpretation of extraordinary cruelty, therefore his conduct as ordinary cruelty qualified for the upward departure provision. He did not argue that he did not aid or abet multiple animal fighting ventures. Hackman also stated that his conduct, being labeled as extraordinarily cruel, would be considered a double count. So basically, since his base offense was his first conduct, he believed that the upward departure would be basically the second that supports the upward departure. So basically, the ordinary cruelty combined with the extraordinary cruelty he thought would be considered double counting. For the issue for Kiriakirides, he made the exact same arguments, or very similar, as Hackman did. Kiriakirides stated that in the case of the electrocuted and executed dog, the execution is not relevant conduct because the killing was sanctioned by the dog's owner. For judgment for both of them, Hackman, the Court of Appeals upholds that the District Court did not make an error interpreting the United States Sentencing Guidelines 2E3(1). The District Court did not abuse its discretion deciding to utilize the upward departure provision from the base level offense. The Court of Appeals upheld that double counting did not occur. For Kiriakirides, the Court of Appeals upholds that the District Court did not make an error interpreting the United States Sentencing Guidelines 2E3(1), and the Court of Appeals upheld that the District Court did not abuse its discretion by utilizing the extraordinarily cruelty upward departure and applying it to Kiriakirides' conduct. For the reasoning for Hackman's sentence was that the Court of Appeals de novo legal review demonstrates that the District Court did not err interpreting the statute, nor did it abuse its discretion deciding to depart upward from the base offense level. A base offense level of 10 for an offense that involves animal cruelty ventures. Since this case was involved in extraordinary cruelty, allows for the upward departure provision. Relevant conduct includes all acts, omissions committed, aided, abetted, counseled, commanded, induced, procured, or willfully caused by the defendant. The Court of Appeals upheld that double counting did not occur because the conduct displayed by Hackman enhanced the punishment, but it was a separate sentencing notion. Since Hackman bred, raised, trained, and sold fighting pit bulls, including fighting them to death, knowing the dogs would be allowed and or required to fight until injured or to the death, the ordinary cruelty conduct of dog fighting justifies the base level, while the cruelty aspects listed above are considered extraordinary cruelty and justifies the upward departure provision. From the instances noted in Slide 5, the Court of Appeals ruled that all those instances increase the harm of the dogs, and this in turn increases the cruelty of the endeavor. Since he violated 7 U.S.C. 2156 and conspired to violate the same statute, 18 U.S.C. 371, this indicates that those statutes were violated by Hackman numerous times, and he racked up an offense level of 10 for possessing one fighting pit bull terrier, regardless of any cruelty that was involved. And the reasoning for the sentence for Kiriakirides' appeal was that since Kiriakirides bred, raised, trained, and sold fighting pit bulls, including fighting them, knowing the dogs will be allowed and or required to fight until injured or to the death, the ordinary cruelty conduct of dog fighting justifies the base level offense, while the cruelty aspects listed above are considered extraordinarily cruel and justifies the upward departure provision. A base offense level of 10 for an offense that involves animal fighting ventures. Since this case was involved in extraordinary cruelty, allows for the upward departure provision. Relevant conduct includes all acts, omissions committed, aided, abetted, counseled, commanded, induced, procured, or willfully caused by the defendant. The Court of Appeals upheld that the mutilating or harming of a dog, whether the execution was legal or not under Missouri law, was enough to satisfy the extraordinary cruelty requirement and uphold the upward departure provision. For the final deposition for this court case, the final deposition of the case concluded that the U.S. Court of Appeals ruled in favor of the appellee and the United States. No remedy was granted during this court case. The appellate court affirmed that the district court's ruling on the upward departure provision and upheld that the appellate's conduct displayed extraordinary cruelty. And then finally, for my analysis, I absolutely do not agree or approve of dogfighting whatsoever. I believe that the U.S. Court of Appeals upheld the right decision and held the defendants accountable for their actions. I completely agree with the district court utilizing the upward departure provision for cases like this. Dogfighting is completely inhumane and unethical. If more dog rings could be upheld to the upward departure provision, maybe these individuals would realize they are getting away they're not getting away with just a slap on the wrist like previously anymore. The only thing I did not agree with is the previous court agreeing to a plea deal for this extraordinary cruelty case. I feel like if these men had been given the original counts that they were issued, they might be sitting in jail for a little longer than just a year. And then these are my references. Questions? Thank you.